Hi students. So in the sequence of completing the 3 criminal laws from the ICSI study material, now I have completed, today I will be completing the BNS Act. Okay. So if you all have sat with me for the previous lectures, this lecture is going to get very smooth. In case if you missed the previous lectures, please go ahead and complete the lectures are there on YouTube. Okay. Now, so we had completed till here. Okay. And now we'll be completing from here. Okay. Now, one thing let me tell you that from what we are doing, it's around 30 marks easily according to me, because Evidence Act, IPC and your CRPC has been repealed. So you could say around 30 marks can easily come into the exam from what I will be teaching you. Okay. So good to go. Just GTG in the chat box and I start. And one request, I will be giving the notes also to the students who are regular in commenting, and many students are given such lovely messages, and I love reading them. Okay, it just gives me more happiness that I am able to reach them and help them. Okay, so please put out your messages for them. I will give this notes of the criminal laws also to them. Okay, so are we good to go? Can we start reading up your messages? Okay, great. Prashanti, nice. Thank you so much. Katioli, nice to have you. So the thing is, I'm making the notes, so that is why I'm taking time. But then these notes also will be for you, and the lectures are going to be top class. Great, Maddie, nice. Let's start. So this is where we had completed, and now we will be doing the balance part and completing. Let's set the camera, lights, camera, and we can start. Okay, Maddie, Kathiroli and Prashanti, thank you so much. Okay, and please, I request you all to share it in your WhatsApp groups and also in your study groups. Please give a shout out to us. We take a lot of effort to reach you all, especially taking lectures in English for you all. Okay, so please inform your friends, your colleagues, your everyone in your study group as well. Okay, thank you. Let's begin. Hi. So now we start with the next part, which is the offenses against property. Now imagine if you have taken a loan. Okay, now this is all offenses against the property. So let's say if you have taken a loan, okay, this is the creditor and this is who's actually the lender of the loan, and let's say this is the borrower of the loan. Okay, borrower of the loan called as the debtor. Now what happens? The creditor has given the loan and the security has been kept. This has been kept as the security. Now if this person, if the debtor is going to default on the loan, there is going to be a default on the loan, the bank will come and sell the asset. So the borrower will try his level best to sell off the asset, to make a gift deed in favor of someone, to try to separate the asset from him. So if he does that, it becomes a crime under the BNS Act. Let's see. So here the law is smart enough to undo fraudulent transfer. So if he makes a fraudulent transfer to anyone to complicate a case, or so that his creditors don't get anything, and he says that I have no assets now, then it becomes it will be invalid. Okay, because there are different kinds of loans that could be there. Some could be secured, some could be unsecured. But looking at the net worth of a person, a bank might give an unsecured loan also. For example, a credit card loan. But now what you do, you know that you're going to default, so you transfer all your assets to all other people, or you hide it off. So in that case, if you do it so that the creditors go at loss, then it's a crime, because your intention is to defraud the creditors. So it is called as fraudulent deeds, and disposition of property is covered from section 320 to section 323. Okay, so what are the important sections? Fraudulent deeds are from section 320 to 323. So what it says, fraudulent deeds and disposition refers to acts where a person dishonestly removes or transfers the property with the intention so that the assets could not be distributed among the creditors. Now, let's read the section. Section 320 of the BNS Act. Dishonest or fraudulent removal or concealment of property to prevent. Why are you doing it? To prevent the distribution among the creditors. So the penalty has been given that whoever dishonestly or fraudulently removes, conceals, delivers, transfers, okay, to any other person without any required adequate consideration with the intention. What is the intention? With the intention of preventing it so that it would not be available for the creditors, will be punishable with punishment which is not 6 months to 2 years, fine, or both. So what is the line? Whoever dishonestly or fraudulently transfers a property without adequate consideration. I give it a gift deed. I transfer it for 1 rupee. So so that I don't have any money only. So creditors, when they file a case, they will not find anything in my bank account. So if you do it to anyone without adequate consideration, with the intention of preventing the creditors from recovering the property or getting an amount, so that you would not have any property to distribute among the creditors. This is punishable with minimum 6 months to up till 2 years, fine, or both. Next, let's see the case laws. Now the case laws is, first one is Ramachutar Chaktani versus Hari Ram Todi. Okay, the Guwahati High Court in the case laid down the essential ingredients. In this case, what did they say? What did they lay down in the case? The essential requirements of this case. So first of all, if I'm trying to understand what are the essentials, first of all, there will be a transfer. It will be without valuable consideration, and the intention is to defraud the creditors. Finish. So the commission of the act. The commission means you have transferred, concealed, hidden, removed, anything, the property to any other person. This is the first thing. Without proper consideration. And the intention is to defraud the creditors. Okay. And it has been done fraudulently or dishonestly. So if all the 4 ingredients are there, then you can be punished for an offense of fraudulent. It could also be called as fraudulent removal, or in simple words we can call it as fraudulent transfers. Fraudulent transfers. Simple. Okay, fraudulent removal, fraudulent transfer, it is there. Next, now we are done with section 320. Now we'll see section 321. Now this is very interesting, a variation of this. Same essentials will be there, that there is a fraudulent and dishonest thing happening here, and it is same to prevent that the creditors don't get anything. So again, it is another scenario where I am trying to do a fraudulent act so that the creditors don't get anything. Let's see what is a fraudulent act. Whoever dishonestly or fraudulently prevents any debt due to himself, means he is supposed to get some amount, okay, from being available according to law, okay, for the payment of his debts, shall be punished with the imprisonment which may extend till 2 years or fine or both. Now, what is this? Let's understand. I'll take an example first. A is the creditor and B is the debtor. So A is the debtor and B is the creditor. Okay. So now the creditor knows that if he defaults, I will go and take away his assets, etc. Now what happens is, A has to pay 1 crore to B. So A has to pay rupees 1 crore, he has to pay to B. Clear? Now what does A does not have the money. A does not have the money. However, X, a person, has to pay rupees 1 crore to A. Now imagine if there was Mr. X. He is liable to pay 1 crore. He is liable to pay rupees 1 crore to A because A must have given him the loan. Okay, if X pays to A, then A can repay B. But now A says that he will not get anything. So A does not take the payment from B and informs X not to pay to him. This is a fraudulent intention and will be liable under section 321. Now what is essential in 321? You are preventing a debt that is due to you, that is receivable to you. You say don't give me because it will be taken away ultimately. So this, where you try to prevent a debt, prevent means you say that don't pay me the loan which is due to himself. Okay, so you try to deny to receive the loan you gave to others, because if you get it then you will have to pay your creditors. So if anyone fraudulently or dishonestly prevents any debt due to himself, so it is due to himself means what? Receivable. Okay, if he was supposed to receive and then he denies it, then he will be punished under law. Simple. Then we come to one section, though it has been given in the BNS Act 322, however it is covered under a dedicated section or dedicated act, that is the Benami Prohibition of Benami Transactions Act. So we'll read what it is. So fraudulent and dishonest execution of a deed of transfer. So there are deeds of transfer containing false information of consideration, etc. Now let me explain. It's a very interesting thing. If you know that builders who are there, and there is a purchaser of property, Now what happens is, purchasers of property, normally they have some amount of black money which they have not disclosed in tax, and some they have white. So what do? They give 30% black money, that is in cash, and 70% they might pay in check. Okay, so what happens? Why would you do this? Any idea? It is it's used to be done very commonly before. Now government has put some strict regulations and all these penalties have been there in the BNSS Act. What do you do? So what they used to do, the property value, let's say if it is 1 crore, if the property value is 1 crore, in the agreement it will, because white money I give the cash to the builder, I say you give me the flat of 1 crore, whatever amount, you just take 1 crore, just show it on that. So 1 crore flat, 30 lakhs you take cash, 70 lakhs you take in white, and make an agreement only of the 70 lakhs. So the agreement will be made of 70 lakhs, and then stamp duty will also be paid on that amount, and registration will also be paid on that amount. So what will happen? You're giving a false consideration received to avoid stamp duty, to avoid being recognized under the court of law, etc., of your income. So all this is also, if you do dishonest, fraudulent ways, you sign any deed. So now what you do, you make a sale deed, you sign any deed which has a transfer of the property there to you, but which contains a false information relating to the consideration of the amount. So consideration is shown 70 lakhs, whereas the real consideration given is 1 crore. Okay, then that person will be punished for imprisonment, which may extend to 3 years, or fine, or both. So very, very strict BNS Act has come down on this black-white money case. Second, they also tell that this comes under the Benami. This comes under the Benami Transactions Act. Benami Transactions Act means what? It is shown on paper that this one is buying, but in reality the beneficial owner is someone else. A politician is there, he doesn't want to come on the record, so he keeps the name in the name of the driver. So what is happening is, the real beneficial person is someone else. So it contains a false information, false statement with respect to for whose benefit the property is being held. The politicians who's a real owner's details are not coming, so there is a false statement that Mr. Ramu is buying the house, whereas in reality the Ramu's owner is the main person who's paid the consideration, etc. This thing is covered under the Benami Transactions Act. Okay. Now, scope of section 322, very simple. There are two things. Consideration amount, there is a false information with respect to the consideration, and there is a false information of whose benefit the property is held. Relation to Benami's Act, dishonest execution of a Benami deed is covered in the Benami Transactions Act 1988. Okay. Now we come to another thing. This we talk about dishonest and fraudulent. So this is a common word for everything. Okay. For all those things, dishonest and fraudulent, we'll write removal or concealment of property. Concealment of property. For example, if I know that the bank is going to come, I hide all the jewelry, I hide all my cash amounts, I hide any kind of valuable that is there in the house. So I take this switch, and behind the switch I put, behind the walls I put, so that when anyone comes to take, they will not find any valuable assets in my house. So if you try to conceal property, hide the property, you are also, or anyone who assists, who helps also will be stuck, who will be punished. So whoever dishonestly or fraudulently conceals or removes any property of himself, so any my own property, I try to hide it, or anyone is trying to help also to hide or remove it, okay, so that the demand dishonestly releases any demand or claim to which he is entitled, and I say that, listen, the demand which is there from me, I'll say I don't have money, so will be punished with imprisonment which may extend to 3 years or fine or both. Very, very simple. So an example is being given that A is the debtor who has to pay to B 50 lakhs. Now A owns a valuable painting, let's say valuable jewelry. So to avoid paying B, A hides the painting in a friend's house. So both can be held liable. He can also be held liable, and his friend who has assisted him with this knowledge will also be held liable. Now we come to the next section. Okay, next kind of offense, which is a very, very important offense, which is called as forgery. Forgery is with documents. This document could be in physical paper or in electronic means. For example, if a check, you've taken the sign of someone, you forged the sign, you faked the signature of someone, it is amounts to a offense of forgery. Next, you make a fake caste certificate, so that also you can be held liable under forgery. Third, if nowadays politicians have fake degrees, okay, fake degrees they take, so even they can be held for forgery. Let's take this offense relating to documents, property. Okay. Now we are seeing offenses related to documents and property marks. So we'll see what it is. First we'll talk about documents. Documents is direct forgery. So whoever makes any false document or an electronic record or part thereof with the intention to cause damage to someone, get any title or any claim or any benefit, okay, make a document so someone gives me the property, sells the property to me, makes someone enter in a contract. So I forge a document and I make someone enter into a contract, or to commit fraud, commits forgery. So basically the main offense is you make any false document or electronic record and with the intention of causing damage, okay, to someone, or inducing someone to enter into a contract or give their property, or to get any claim or title. For example, you get a caste certificate and because of that you claim benefits, you claim ration, all the ration card, etc. you make. So then you commit forgery. What is the punishment of forgery? If a person commits forgery, they will face imprisonment up to 2 years or fine or both. If forgery is done with cheating, so cheating and forgery clubbed, then imprisonment can go up till 7 years. Forgery is done to harm someone's reputation, then you can get imprisonment up till 3 years. Now case laws on forgery. Very simple kind of case laws have been given. Ramchandran versus State. Mere creation of a false document without fraudulent intention does not amount to forgery. So what does it say? Mens rea is required. Imagine if in bona fide interest I made some document, I cannot be held liable under forgery. Second, mere alteration of a document is not forgery unless it is for gain or a certain objective. So we saw the intention has been given for what all intention is there to get any claim. If I'm not getting any benefit after forging, for example, my grandfather is there, he had made a spelling mistake. I went in the document, I made the correction. So in that case, what happens? I made the correction, I didn't get any benefit. So it is not forgery. So you alter a document, okay, but there is no benefit, there is no harm, all those, there is no loss, then it cannot be held for forgery. Okay, your intention is there that you should get some benefit, you should cause some harm, okay, etc. Balbir Kaur versus State of Punjab. The accused submitted, now very important, they have asked in the past exam also. What it is? Balbir Kaur versus State of Punjab. Now what happened? There was a teacher. Okay, there was a teacher. She had taught. She had a past experience. She had a past experience in a unrecognized school. She didn't know it was unrecognized, etc. And she gave only her qualification. She didn't say that it is recognized, unrecognized. She just gave the facts that I have worked in XYZ school. Can she be held for forgery? That listen. So first of all, she gave her past experience and it was a fact. And she has nowhere claimed that it was recognized. In such case, it is not forgery. So the accused submitted a certificate for employment, but the school was not recognized. The certificate did not falsely claim recognition. Then obviously it is not forgery. Okay, it was held that it is not forgery. Let's see the next one. With respect to trademarks, they are calling, for example, if someone has violated a trademark. Adidas, they made Abibas. Puma, they made Puma. So very similar thing. They have made it extremely similar. So is it a criminal offense? Answer is yes. Under section 345, infringement of someone's trademark, property mark, whether it be service mark, anything, could lead to punishment under section 345 and imprisonment also. So these are some of the counterfeit products. Kit Kat, and they have made Kick. So it looks very similar. Packaging is same, color is same, font style is same. So it is to confuse. Another, if you see Coca-Cola, so it's Coca-Cola, Coca. Very similar. Then if you take Lay's, it comes to legs. Or Colgate is Coolgate. So these are all what? These are not original brands. Someone is come to take the reputation of the original brand. So let's see. These are all called as violation of property mark. Now what is a property mark? First of all, these are all treated as movable property. So whenever someone uses a mark, identification, a logo, a symbol, which belongs to a particular person to denote as their own product, it is called as a violation of someone's property right. So property mark is basically a mark which is used to denote that a movable property belongs to a particular person. Simple. So Apple belongs to Apple company, right? The Nike logo belongs to the Nike company. Now if someone falsely uses this mark or a similar product to create deception, they will be held liable. So whoever marks any movable product, etc., in a way that it misleads others into believing that the property belongs to someone else, okay, or uses a replica with such a misleading mark, is said to be using a false property mark. So in the exam they can ask you about false property mark. So what is a property mark? First you will mention it is a mark of someone who has in business trademark. If someone uses this property mark to mislead others to believe that they belong to someone else, then it is called as using the false property mark, and you will be punished with, you can be punished for imprisonment up to 1 year, fine, or both. Okay. Now we come to another important kind of offense which is called as defamation. Now let's understand what is the meaning of defamation. So if one sees, okay, so if one sees, what do you mean by defamation, the meaning? So defamation is a statement which is false, which lowers a person's reputation in society. So what is defamation? It is a statement that lowers a person's reputation in the society and it is false. So let's see the definition. Okay, this statement could be written in the form of anything. Okay, whoever by words, signs, visible representation, anything, publishes any imputation. Imputation means connection concerning a person intending to harm, his reputation, is said to defame that person. So first thing, let's understand, whoever by words, signs, or visible representation makes a imputation. Imputation means a connection with any person with the intention to harm that person's reputation, is said to defame. For example, you made a cartoon. For example, you've written a news article. Okay, this is all can come under defamation. Very, very important. Can you defame a deceased person? Yes or no? What do you think? Can there be defamation of a deceased person who is not alive? So obviously yes, if you make a Michael Jackson is not alive, but you make a movie about him, it could amount to defamation. Because how do you define it then? You would say that if he was alive, this would amount to defamation. So for example, someone is making a movie on Gandhiji, okay, saying that he was not a nice man, and it is false, then the person, the makers, can be sued for defamation by Gandhiji or any of his legal heads, etc., that he's made a false statement. Okay, it can be defamation to if you're imputing about a deceased person, if that imputation would harm the reputation of a person or hurt the family or his close relatives, and it is false. Next, defamation. You can even defame companies, okay, by saying that Reliance is a thief, Reliance is and it is false. Okay, Reliance is selling, Nestle is selling adulterated products, when it is false. They can sue you for defamation. Okay, ironical or alternative imputation. Imputation means what? A connection. You are trying to impute, connect something. Okay, made ironically or in an alternative form. So I'm not directly saying who I'm doing. I make a cartoon. Okay, and that cartoon caricature, or maybe I make some kind of a statement a logo or a symbol, or maybe you could say a jingle, with when we say, we know who you are talking about. So that ironically, like a irony you are creating, is also a particular defamation. Next, when an imputation lowers a person's reputation. Okay, when an imputation lowers a person's reputation, imputation is considered harmful if it lowers a person's credit worthiness. Okay, normally what happens is, when we say that a scam has been done by Adani company, so automatically the share price drops, their credit worthiness reduces, their loan getting power reduces. It affects the moral character of a person, caste or profession. If I say that he is a doctor who is selling kidneys in the black, that also is a negative thing, or causes others to believe that the person's body is in a disgraceful or a loathful state. So if I say that he is a very dirty person and people start looking down upon you, okay, if I say that he has done this alleged offense, okay, so then you would not any person is if I say that he has done this crime, okay, and he's been guilty, where it is all false, so in that case it will be said that it is harmful to him. Illustration. Okay, now even indirect imputations can be called as defamation. For example, I say Z is a honest man, he never stole. It is intending to apply that Z actually stole the watch. It can also be called as defamation. If I say that they two are only friends, the way you say and how it is perceived by others can be counted as, yes, it is harming the image of someone else. A points as Z when asked who stole the watch. This is also defamation. So it is an imputation which lowers a person's moral character. A draws a picture of Z running away with B's watch. This is also defamation. Now, exceptions to defamation. What are not defamation statement or defamatory? What are not defamatory statements? So I'm thinking that what is not defamation? A criticism is not there. A honest criticism. So wherever you prove that you honestly meant it, okay, then it is not defamation. For defamation, it has to be false. So let's see. A public good. If the imputation is true, then obviously there and made for public good, it is not defamation. Simple. It is true, public good. If I say that this person has been convicted for XYZ offense in the past in 2019, and if it is true, he can't sue me for defamation. Second, opinions on public servant. Good faith opinions on the official conduct of a public servant are not defamation. So if I'm saying that this police officer didn't do his job properly, so I'm giving a good faith opinion. Now again, what always they use the word true, good faith, good faith. So obviously it cannot be defamation. If you give an opinion on a public question, okay, it is not a defamation. Next, reports on court proceedings. A substantially true report on the court proceedings is not defamation. So obviously on the court's proceedings, if any comments has been made, it is not. I say that it took 10 years, 10 long years, the court is very slow. It is not defamation because it is true. Opinions on the court's decision. So if imagine you are not happy with the court's decision, you have a absolute right to express your dissent, unhappiness. It is not defaming the court. It just shows that you do not agree with the court. So expressing a opinion in good faith. Good faith is the most key word about the merits of the case, about the parties, about the witness, about the character of a person is not defamation. Criticism of public performance. So you saw a movie and you did not like the movie. You said it's a horrible movie. It's a disgusting movie. Nobody can file a case on you. This centuries by criticism or criticism by authorities. So censoring means criticism. So if a judge has criticized the police officer's duties, that you did not do your duty properly, okay, in good faith, then obviously it is not defamation. Complaints to authorities. I made a complaint to the authorities in good faith. I said that I feel that he has done the theft, the robbery. So I said in good faith. I gave a complaint in good faith. I thought that he has done it. In reality, he must have not done. But I did in good faith. Question is over. Imputation made for protection or public good in good faith. Okay, again when I say good faith, for protecting one's own interest, protecting someone else's good interest, and protection for public good. Nowadays, if you've seen, there are many, you could say food bloggers, or we could say there are a lot of whistleblowers who are coming in and saying they are like, private people who go on to expose certain things. They say that, don't have this kind of, mango pani puri. It will cause your heart rate to go very high. Or do not have this chocolate cake, double chocolate cake, or do not have a McDonald's burger. It is completely unhealthy. Okay, and it is made from XYZ things, which is very cancerous. Now this I said it for public good. No case can be filed on you. Okay, next, giving a caution in good faith. Similar things, everything, giving a warning in good faith. Okay, if I tell that, listen, he has defaulted my money, don't ever do business with him. It's a honest freedom of speech and expression. It's my belief, good faith. Okay, now very, very important, there are two kinds of defamation. Defamation can be of two kinds. One is slander and the other one is called as libel or libel. Slander is by words, slang, words. So this, you have said that you are a thief, you are morally bankrupt, or if I say that you are a person who is coming from a extremely bad family background. So this is slander, okay. So slander is by words. It is in temporary form, by words. There is no other recording, no other writing, etc. So slander is very difficult to prove in court, because I say I can very well, if there is no proof, there is no concrete form of proof, then obviously it becomes very difficult to prove in court. So normally slanders are dismissed only because the other person will say I didn't say. Libel are more serious forms of defamation where it has been recorded. There is a permanent form. Maybe it could be in the form of a video, could be form of a reel. It could be in the form of someone who comes in and says that there is no scope in CA, CS, CMA on YouTube. Now the entire industry will file a case on him, because first of all, there is a tangible form of evidence. There is a concrete evidence that we have. It could be in writing, it could be in picture, it could be in video form. So that is libel. Okay, now very funny example is a person, a writer was there. He wrote an article that millionaire Donald Trump has gone to Europe. Donald Trump filed a defamation case on him. He said that I am a billionaire. I am not a millionaire, I am a billionaire. So he wrote the letter because claiming that he is a millionaire, he is a billionaire, not a millionaire. So he also filed a defamation case that it is amounting to lowering his reputation. Very simple. Okay. So kinds of defamation. Defamation can be of two kinds. Libel is more serious. It is in a permanent visible form. Writing, any book that you've written on someone. Slander is by words in a transitory form. Transitory means what? Temporary form. Maybe I just said and now you don't have any proof of it. Okay. Now, when we say it should be published, so published means what? I have communicated to anyone else other than the person. So when I say I have published it, means what? If I put it on my Twitter account, means apart from you, others can also read. So moment it reaches to others, it can be said that it has been published. Case law, Sankaran versus Kram Krishna Pillai. In this case, the defamatory was printed in Malayalam. Market is important case. It was held that there was no mens rea in his case. No mens rea. Okay. So, in this case, the defamatory article was printed in Malayalam, but the accused didn't understand the language only. So, the mens rea was absent, because if you are saying that I have defamed you, but I don't know the language only. So the question of intention was not there. For example, any article, any interview was there, and I have not translated it, I have not done anything, so I didn't have any intention, you cannot sue me. That was the entire point. How much punishment you get for defamation? Okay. Section 356 says if you have done defamation, you'll get up to 2 years fine or both, or community service. Now community service could mean for slander, could be given. Okay. However, if you've done in any material which is defamatory content like a article etc, then 2 years, or so libel could be punished up till 2 years, and selling also the defamatory article, then so you will get simple imprisonment, 2 years, fine, or both. Now we come to general exceptions. Let's understand what it is. If let's say you are a criminal lawyer, you have to defend the accused. Okay, so you will have to look for defenses for accused. Right? You are trying to defend the accused that he is not guilty. So then I will have to look at certain things. The BNS Act also says that when you will not be held guilty. So important, the BNS Act chapter 14 to 44. Okay, chapter 3 covers about general exceptions. It will show you when mainly all these cases you didn't have mens rea only, so then you will not be held liable. Let's see. So they have given you various categories. General exceptions to offenses means if you do this, you are falling under any of this, you have not committed an offense. I'll give you some examples. If, for example, I had done something in self-defense, maybe I might not be punished under the law. Or if I had done anything in good faith, I will not be punished under law. If I had done anything which the court has told me to do under the duty as a statutory duty, I will not be held liable. Let's see. If a child has done something, age, you will not be held liable. Let's see the points. Act done under a legal obligation. Okay. For example, nothing is an offense if made by a person who by reason of a mistake or a fact and not of law in good faith believes it to be true. A soldier ordered by his superior to fire at a mob in a riot, believing it to be a lawful order, is not guilty of the offense. So there was a mistake of fact. Okay. In such a case, in good faith, if I have done, it will not be a particular offense. So act done under a legal obligation. So if someone has told me that arrest him, I am the officer, so I went and I arrested him. Later I found he is not guilty. I cannot be held liable because I did it under a legal obligation in good faith. So not every time you catch the right person. Sometimes for investigation you have to detain some other people also. Even judges will not be held liable. For example, a judge gave an incorrect statement. Will the judge be held liable? No. Judges acting under law judicially in good faith cannot be held liable. Not only that, someone acting under the judge's order, for example, a hangman, the person who gives hang till death, later we found that he is innocent. The accused, after everything, we had given him punishment etc, and then we found that he is innocent. Can he sue the judge or anyone who the officers etc. Answer is no, because they acted in good faith. Okay, so by a court order, court told me to imprison him for 2 years. I imprisoned him on the court's order, so I will also not be held liable. Judge is also safe, officers are also safe. Why? Because they acted in public interest or in good faith. Next, act justified by law or mistaken belief. If A believes, the more or less the points will be very similar and overlapping. If a person believes in good faith that they are justified to do by law, it is not an offense. A police officer arrests B, believing B to be a criminal by mistake, will not be held liable. Okay, justified by law, mistaken belief. Next, accidental death. For example, in a cricket match, a ball strikes on a man's head and he dies. You remember there was a Australian cricketer, Philip Hughes. Now what happened? There was a bowler, he bowled and it hit Philip Hughes and he died. So it was a case of accident and misfortune. During a lawful act, without criminal intention, is not an offense. Acts to prevent greater harm. Acts to prevent greater harm. For example, a doctor amputates an infected leg to save his life. Since he acted in good faith and to prevent you from dying, it is not an offense. So act done with knowledge of possible harm, but in good faith to prevent a greater harm, is not an offense. Okay. So for example, we know that sometimes we have to amputate the leg so that we can help protect the body. Doctors will not be held liable since they acted in good faith. Now very simple, now they're talking of age related offenses. So here they've said a child under 7 can never be held guilty. A child under 7 cannot be criminally guilty. So this child, do you think you can put him in jail? Answer is no. But beyond 7, now there is another offense category that they've given you. Very interesting. Okay, nowadays this is a new thing. Nowadays people are capable of understanding. So between 7 to 12 they are not liable. So 7, below 7 are not allowed, but above 7 up to 12 cannot be liable unless they have sufficient maturity to understand their actions. So if someone can prove that this is a 11-year-old, 12-year-old and he understands perfectly, he is in his senses, he knows what he is doing, then he can be held liable. Okay. And for them we have a different kinds of punishment. Could be like a juvenile courts, juvenile justice, etc. Acts of persons of unsound mind. So unsound mind doing anything will not be held liable. Okay, a person incapable of understanding their actions due to their mental state will not be held liable. Similarly, if a person has been intoxicated involuntarily, they will not be held liable. Involuntarily means what? Without consent. So if someone forced you to have alcohol and then you did some crime, you will not be held liable. If you did voluntarily, you can be held liable. If intoxication was voluntary, the person is liable. Simple. Next, acts done. Now this was in the case of a boxing match. Acts done with consent but without the intention of death. So if a person agreed to box, injure each other in MMA fights nowadays, why? It's not an offense because you gave consent. Consent is given for fighting. So if an act does not intend to cause criminal wrong or consent has been obtained, then it is not an offense. Next, act done with consent for a person's benefit. Doctors. So with the patient's consent, a doctor does a surgery, and while doing the surgery, a risky surgery, the doctor has to take some immediate measures. He will not be held liable. Acts done for the benefit of a child or unsound person. Okay. So if done with the guardian's consent, it is allowed. So for example, vaccination of a baby. Okay, a baby is there and now you are injuring the baby, right, by injecting, but with the consent of the guardian and for the good of the child in good faith, not held liable. Consent given under fear. Okay, so basically, if I tell you on gunpoint to rob a bank, on gunpoint, if I tell you to sign a contract, so though you have given consent, but it was not free consent. Okay, consent is not valid if it is given under free. So even if someone has, a woman is there, she has signed a contract, but if she can prove that it was under force, then the consent will not be held liable. Okay, offense is not covered by consent exception. So very interesting. Here, even if you give consent, this will still be an offense. Still an offense. So abortion, illegal abortion. So in abortion, what happens nowadays? Certain couples, they are there. They decide that they want to go and abort the child. In India, abortion is not allowed beyond a few days or months. After that, the fetus is developed. So it will amount to an unborn child in the baby and having legal rights. So if beyond the timeline, if abortion is done, it is called as illegal abortion. Even if consent is given of the parent to abort the child, it is a crime. Okay, your consent does not matter. Acts done in good faith obviously will not be covered. Communication made in good faith will not be covered. Acts done under instant threat. So if I force you to sign a contract or pick up the goods, stolen goods, and put it in the bag, not a offense. Acts causing insignificant harm. So if you have stepped on someone's foot, so there is a minor, no reasonable person would complain. If a harm is caused so minor that no reasonable person will complain, then it is not an offense. Now, very interesting, another point that they've added in the BNS Act, very, very important, even from exam point of view, is self-defense. They've covered a different kinds of self-defense that is there. Okay, because nowadays what happens if someone is coming to attack you, someone is coming to attack your property, someone is coming to attack any of your loved ones, do we have the right to protect ourselves? Answer is a absolute yes. You will not be held guilty if you did an act in self-defense. Let's read. So, right of private defense is provided under Chapter 3 of the BNS Act, covering from Section 34 to 44. You, in order to protect your body or property against unlawful act, you have been permitted. Let's see. Things done in private defense. Nothing is an offense if it is done in private defense. Right of defense of body and property. So you have a right to defend what? Your body also and your property also, like theft, etc. You can protect yourself and fight for your property and for your life as well. Defense against acts of unsound person. Now, can you defend a person? Can you defend from acts of an unsound person? If an unsound person has caught a stick and has coming to hit you, you have a right to defense against them also. If a person commits an act, okay, because he is unsound mind, intoxicated, immature, you have the same rights of self-defense as if the offense is being conducted on you. So you can stop an unsound mind from attacking you. That is also fine. Acts where private defense is not allowed. If against a public servant, okay, a public servant is there, you cannot defend yourself if he is catching you. If there is no apprehension of grievous hurt or death, okay, and if there is time to seek help from the authorities. The defense must not exceed the necessary harm. A police officer tries to arrest B on the suspicion of theft. B does not have self-defense. Only when you can use a self-defense if you are threatened for life or a very serious hurt, because that the police officer can't do. Next, right to cause death in private self-defense case. Now imagine, are you allowed to cause death of the attacker? A person may cause death of an attacker in private defense only in the following cases. Very, very important. If there is you have a apprehension, a belief of death or grievous hurt, or it is to with the intent to rape, kidnap, wrongfully confine a person, or do acid attack. So these are the things: death and acid attack. So these 3 points you can remember. In this thing you can cause the death of the assailant also. Right to cause a harm other than death. In all other cases you can defend yourself, but you do not have a right to kill the attacker. Okay, you can only cause harm to the in defense. You can cause harm in private defense on the attacker, but you can't kill them in all other offenses. When private defense begins and ends. So let's say so this normally happens like say some robbery has come. So from when I can start defending and when I have to stop defending myself. So the right starts when a reasonable threat arises. So moment the threat arises is when it starts. So when it starts, when the threat arises, as long as the danger persists, and continues. When does it end? Till I am in danger. Okay, till you feel that you are in danger. During this time you can do self-defense. Then right to cause death in self-defense, we've seen all these cases. You can cause death. In all these cases you cannot begin and death. Then private defense against deadly assault with risk to innocent. If a person is attacked and cannot defend himself, without the risk to an innocent person. So it is happening that while doing defense, I might end up injuring someone, so it is allowed. It is still justified. A is attacked in a crowded street. To defend himself, he swings a stick, accidentally injuring a bystander. There is no offense. Clear? With this, we've completed the entire BNS Act, which was earlier called as the Indian Penal Code. Thank you. Clear? Everyone clear till here? Shobika, great. Okay. So that is it for today. We have completed the entire BNS Act has been completed. Next, we will do the BNSS Act. Okay, from tomorrow onwards, we will do the BNSS Act. BNSS is nothing but the CRPC. This was what? This was the IPC. We have completed it perfectly. Or every single thing has been completed and not a single question can come outside than what we do. And now we will start it from tomorrow. Okay, so that is it, guys. Do like the video, share it with your friends, and do inform me if Wilram, nice to have you. I think you're the first time you're messaging. Great. Shobika, nice. Jitin, great. Okay, great. Thank you so much. I will see you all in the lectures. Your job is to complete the previous lectures also of the BNS Act and keep it ready. Okay, so I have gone from the ICSI latest material and I have completed. That is it, guys. Thank you so much. Jitin, Velram, Shobika, Maddie, Katrioli, Shanti. Nice. Bye. And do share it with your